So a very warm good morning to all of you. I hope all of you are doing great. So let's start today's discussion. Now, today we are planning to discuss, we are going to talk about your MP Civil Judge 2019 Phase 1 question paper, in which we are going to talk about your CRPC, as well as we are going to talk some of the things about CPC and Constitution. So basically, we are going to cover two of the question papers today. And today, along with 2019 Phase 1 Shift 1, we are also going to discuss about 2019 Phase 1 Shift 2 question paper. If you, good morning Harshvardhan ji, if you haven't subscribed our channel till now, please go and subscribe the channel and don't forget to press the bell icon. Now, and if you haven't checked out MP Civil Judge Prelims Crash Course, link is in the description box. Just go and check out the link. Now, today's first question, that is question number 101. That is, if it appears to the magistrate that the offense complained of is triable exclusively by Court of Session, then under section 202 of CRPC, postponing the issue of process against the accused, A, option A is saying, shall commit the case to the Court of Sessions. B, may direct an investigation to be made by a police officer. Option C, shall call upon the complainant to produce all his evidence and examine them on oath. And D, shall return the complaint for presentation before the Court of Session. So what should be the correct answer? Question number 101. Yes, this particular question is related to section 202, or we can say section 202 of CRPC. Right? 202 of CRPC, postponing the issue of process. So what the magistrate has to do after postponing the issue of process? Ankita Gupta. Good morning, Ankita ji. I hope all of you are doing great. I am audible and visible to all of you. So what should be the correct answer for question number 101? Can anyone tell me what should be the correct answer? Yes. Question number 101. Any idea? Question number 101. What should be the correct answer? Yes, its correct answer is C. That is, shall call upon the complainant to produce all his witnesses and examine them and on oath. And after that, the court can, the court feels that the particular suit is triable exclusively by Court of Session, then the court can postpone it, right? The magistrate can postpone it under section 202. Next, question number 102, that is, plea bargaining is applicable to the offenses other than the offenses which are punishable with death or imprisonment for life or imprisonment. Yes, Harshvardhan ji, 101C is the correct answer, right? Death or imprisonment for life or imprisonment for a term exceeding dash years has been provided. Option A, 7 years, option B, 5 years, option C, 2 years, and option D, 3 years. So here, if you will follow up question number 102, it is related with chapter 21A of CPC, that is talking about plea bargaining. So it is clearly mentioned. Yes, Ankita Gupta ji, C is the correct answer for 101. 102, plea bargaining chapter is applicable on the offenses which are like not punishable with death or imprisonment for life or for imprisonment of a term exceeding 7 years. Yes, Harshvardhan ji, A, Ahmedabad is the correct answer, that is 7 years. Next question, question number 103. Under section 313 of CRPC, the statement of the accused, A, will be recorded on oath, B, will be recorded without oath, C, either on oath or without oath as per the discretion of the court, and D, court can exempt from oath. So what should be the correct answer for 103? Under section 313 of CRPC, the statement of the accused, A, will be recorded on oath, B, will be recorded without oath, C, either on oath or without oath as per the direction of the court, and D, the court can exempt from oath. So what should be the correct answer for 103? Yes, if you people have followed up that particular topic, which is talking about various general provisions like section 300 to 327. In this, numerous of sections are important, including section 300, 303, 304, 306, then 311, 311A, 313, 315, 319, then 322, 323, 325, 326. So this particular chapter is very much important. Yes, question number 103. Its correct answer will be B for Bangalore. That is, will be recorded without oath. But remember, if suppose here on the place of 313, they have written section 315. Under section 315 of CRPC, the statement of the accused, then the correct answer will be A. That is, it will be recorded on oath. Next, question number 104. Who can issue search warrant in respect of postal or telegraph authority? Who can issue search warrant in respect of postal or telegraph authority? Option A, magistrate or chief judicial magistrate. B, any civil court having competent jurisdiction. C, revenue court of competent jurisdiction. And D, only high court. So who can issue search warrant in respect of postal or telegraph authority? They are asking like which particular authority is authorized to issue a search warrant in the cases of postal or telegraph authority. Yes, question number 104. What should be the correct answer for 104? Just let me know. District Magistrate and Chief Judicial Magistrate B, they are stating like any civil court of competent jurisdiction. C, revenue court of competent jurisdiction. And D, only high court. So what should be the correct answer for this particular question? That is question number 104. Yes, just let me know quickly. What should be the correct answer? Yes, 104. Its correct answer will be A for Ahmedabad, that is District Magistrate or Chief Judicial Magistrate. These authorities are empowered to issue a search warrant in respect of postal or telegraph authority. Next, question number 105. Under the Indian Constitution, Criminal Procedure Code is included in the A, state list, B, concurrent list, C, union list, D, residuary list. In the Constitution of India, yes, Ankita Gupta ji, 104A is the correct answer. 105. In the Constitution of India, Criminal Procedure Code is included in A, state list, B, concurrent list, C, union list, and D, residuary list. Right? So what should be the correct answer of 105? Just let me know quickly. 105. Its correct answer will be B, that is Bangalore, that is concurrent list, right? Now, all of us are aware that the various provisions of Criminal Procedure Code, CRPC, have been designed by central government. But some of the state government made alteration or changes in CRPC depending upon the circumstances available to them. So when on a particular subject matter, both state and central government are making laws, that should be considered as a part of concurrent list. Akif Mansoor, yes, Akif ji, its correct answer will be concurrent list. Next, question number 106. That is the maximum amount which may be awarded as an interim compensation under section 143A of the Negotiable Instrument Act 1881 will be A, 10% of amount of check, B, 20% of amount of check, C, 30% of amount of check, and D, 40% of amount of check. Maximum amount which can be awarded as interim compensation under section 143A of Negotiable Instrument Act. 10%, 20%, 30%, and 40%. What should be the correct answer? So its correct answer will be question number 106. Its correct answer will be B for Bangalore. That is 20% of amount of check. Here you have to remember that as per section 143A, yes, Akif Mansoor, B is the correct answer, that is 20%. Here you have to understand that here they have written the word maximum. maximum amount may be awarded as an interim compensation under section 143A. But let's twist this question. Suppose if the question comes, the minimum amount which may be awarded in the cases of appeal as a compensation under section 148 of Negotiable Instrument Act. Now, whatever I have stated in this question, hear this question very much clearly. Yes, Ankita Gupta ji, B is the correct answer. The minimum amount which may be awarded as interim payment under section 148 of Negotiable Instrument Act 1881. Its answer will also be 20% of amount of check. But in this case, that is minimum amount. Like suppose the court passes decree in favor of a particular person who has filed a suit for the dishonor of check, and the next party wants to appeal in High Court or in other appellate authority. Then the appellate authority may say to the person who has dishonored the check against whom the judgment has been passed, Premanand Sahu, yes, B is the correct answer, Premanand Sahu ji. Okay? So the court can simply state this statement. What the court is going to convey, the court is simply going to convey that before hearing your issue, what we are ordering you, kindly pay minimum 20% of the amount of check to the aggrieved party. Then only we are going to allow you to make this appeal, right? Now, next question number 107. Under section 97 of Negotiable Instrument Act 1881, when the party to whom notice of dishonor is dispatched is dead, but the party dispatching the notice is ignorant of his death, then A, the notice is sufficient. B, A, the notice is insufficient. B, the notice is sufficient. C, notice shall be given to the legal representative, and D, none of these. Under section 97 of Negotiable Instrument Act 1881, when the party to whom the notice of dishonor is dispatched, that particular party is dead, but the party dispatching the notice was ignorant of his death, then the notice is insufficient, the notice is sufficient. C, the notice shall be given to the legal representative, and D, none of the above. Yes, Premanand Sahu ji. Okay, this is like, I think this is the answer of previous question. 107, its correct answer will be B, that is Bangalore. That is, notice is sufficient. The reason behind that, the party was ignorant. The party who was sending the notice was not aware about the death of that person. But again, under section 97, if the party dispatching the notice was aware about the death of the party, then the notice will be considered insufficient. Akif Mansoor, C, no, Akif Mansoor, its correct answer will be B, that is, notice is sufficient, right? But if the party was aware about the death and then ignores it, then it will be considered as insufficient, right? So its correct answer will be B for Bangalore. Next question, question number 108. According to section 13 of Negotiable Instrument Act 1881, which is not a negotiable instrument? A, instrument of debt. B, promissory note. C, bills of exchange, and D, check. Under section 108 of question number 108, according to section 13 of Negotiable Instrument Act 1881, which of the following is not a negotiable instrument? A, instrument of debt. B, promissory note. C, bills of exchange, and D, check. What should be the correct answer for this question? Just let me know quickly. What should be the ideal answer? Question number 108. Jaldi se ek baar bataiye. Question number 108, what should be the correct answer for this? Question number 108, what should be the correct answer? Question number 108, its correct answer will be A for Ahmedabad. That is instrument of debt, right? So the instrument of debt cannot be considered as negotiable instrument under Negotiable Instrument Act section 13, right? I hope it is quite clear to you all. Now let's move towards your next question. That is question number 109. Which of the following presumption is not prescribed under section 118 of Negotiable Instrument Act 1881? So which of the following instrument of debt is not a negotiable instrument? Yes, Premanand Okay, Akif Mansoor ji, you are correct. Now, next question. Which of the following presumption is not prescribed under section 118 of Negotiable Instrument Act? A, of consideration, B, as of date, C, as of time of acceptance, and D, all of these. Question number 109. What should be the correct answer? If you will read section 118 of Negotiable Instrument Act, that is talking about presumption. There are some other sections like section 138, 139, they are also talking about presumption. But in this question, they are asking about section 118. So its correct answer will be, which of the following is a presumption? Its correct answer will be D for Delhi, because section 118 of Negotiable Instrument Act is talking about consideration, as well as about the date, as well as about the time of acceptance. So all these presumptions. Yes, Akif Mansoor, Premanand Sahu, D is the correct answer. Next question. Question number 110 and the last question from MP Civil Judge 2019 Phase 1 Shift 1 question paper. In which section of Negotiable Instrument Act holder in due course is defined? So which particular section of Negotiable Instrument Act defines the term holder in due course? Options are A, section 7, B, section 10, C, section 9, and D, section 13. Section 7, section 10, section 9, and section 13. 110. What should be the correct answer? Holder in due course. Holder in due course is defined under which section? Section 7, section 10, section 9, and section 13. So what should be the correct answer? Yes. So its correct answer will be C. C, that is section 9. Yes, Akif Mansoor, C is the correct answer. Now let's move towards next. Now we are going to discuss Madhya Pradesh Civil Judge Prelims exam of 2019, Phase 1 and Shift 2 question paper, right? 2019 Phase 1 question paper has been conducted into 2 shifts. So till now we have discussed till Shift 1. Now we are going to discuss with Shift 2. Now, Shift 2, the question number 1 will be, this particular question is belonging to Constitution. Which article of the Constitution of India relates to the subject matter of laws made by Parliament to give effect to treaties and international agreements? Which article of the Constitution of India relates to the subject matter of laws made by the Parliament to give effect to treaties and international agreement? A, Article 247, B, Article 246, C, Article 245, and D, Article 243. What should be the correct answer? 247, 246, 254, and 253. Question number 1. Question number 1 of 2019 Phase 1 Shift 2 question paper belonging to Constitution of India. This is again a direct question from article number. So its correct answer is D for Delhi. That is Article 253 of the Constitution of India. I hope it is clear till now. Now, let's move further. Question number 2. Question number 2 is talking about who among of these determines the question whether a member of Lok Sabha has subject to disqualification on the ground of defection in terms of 10th schedule of Indian Constitution. A, Speaker of Lok Sabha, B, President of India, C, the Election Commission of India, and D, a special committee formed by the Parliament for this purpose. Who among these determines the question whether a member of Lok Sabha has become subject to disqualification under Schedule 10, that is talking about anti-defection laws, right, of Indian Constitution? A, Speaker of Lok Sabha, B, President of India, C, Election Commission of India, D, a special committee formed by the Parliament for this purpose. So question number 2, what should be the correct answer for question number 2? Yes, its correct answer is A, that is the Speaker of Lok Sabha. The Speaker of Lok Sabha is the right person. Yes, Akif Mansoor ji, its correct answer will be Speaker of Lok Sabha. Next question. Question number 3. Language to be used in the Supreme Court and in the High Court and for acts, bills, etc. until the Parliament otherwise provides shall be? A. Yes, Ankita Gupta ji, A is the correct answer. Question number 3. A. Proceedings in the Supreme Court and in every High Court shall be in English language. B. Proceeding in the Supreme Court and in every High Court shall be in Hindi language. C. Proceeding in the Supreme Court will be in English. Out of every High Court, the language shall be regional. D option. Proceeding in the Supreme Court shall be in English and in High Court, the language will be Hindi or as per the choice of the parties. Question number 3. What should be the correct answer? Question number 3. The language to be used in the Supreme Court and in the High Court and for acts, bills, etc. until the Parliament otherwise provides shall be. Its correct answer will be yes. 3 ka correct answer will be A. That is, proceeding in Supreme Court and in every High Court shall be in English language. Yes, Akif, Mansoor, Harshvardhan, Gautam, all of you are correct. Ankita Gupta ji, you are also correct. Question number 4. A professor of university who is eminent jurist is eligible to be appointed as a judge of the. A professor of university who is an eminent jurist is eligible to be appointed as a judge of the. A. In the High Court. B. In the High Court and Supreme Court both. C. Only in the Supreme Court. D. Neither in High Court nor in Supreme Court. Question number 4. Belonging to Constitution of India. A professor of university who's an eminent jurist. He is eligible to be appointed as a judge in High Court and Supreme Court both. In Supreme Court, neither in High Court nor in Supreme Court. Its correct answer should be C. That is only in Supreme Court. Right? ये question ध्यान रखिएगा. Question number 4. Only in Supreme Court, not in High Court. Yes, Akif Mansoor ji, you are correct. Akif Mansoor ji is having firm knowledge. It shows that he is well prepared. Now, question number 5. Who among the following holds his office at the pleasure of President? Question number 5. Who among the following holds his office at the pleasure of President? A. Speaker of Lok Sabha. B. Attorney General of India. C. Comptroller and Auditor General of India. D. Chairman of Union Public Service Commission, or you can say Chairman of UPSC. Who among the following holds his office during the pleasure of President? Its correct answer should be no, Ankita ji. Question number 4 ka correct answer will be in Supreme Court. A person who is a professor in university and an eminent jurist can be a justice in Supreme Court. Question number 5. Options are Speaker of Lok Sabha, Attorney General of India, Comptroller and Auditor General of India, Chairman of UPSC. Question number 5. Its correct answer will be B for Bangalore. That is Attorney General of India. Attorney General of India can hold his office during the pleasure of President. Yes. Next question, question number 6. That is, in the following, which dispute is not covered in the original jurisdiction of the Supreme Court? Question number 6. In the following, which dispute is not covered in the original jurisdiction of Supreme Court? A. Between the Government of India and one or more government of the state. B. Between the Government of India and any state or states at one side and one or more states on the other. C. Between two or more states. D. Pre-constitutional treaties or agreement. They are asking about the jurisdiction of Supreme Court. So this is particular thing which is belonging to, yes, question number 6 ka D is the correct answer. Harshvardhan Gautam ji, pre-constitutional treaties and agreement, they are not covered as a original jurisdiction of Supreme Court. Rest all others, like any dispute between center and state, center and one state at one side and another state at another side, or two or more states, all these are dealt as the original jurisdiction of Supreme Court. Even filing a writ under Article 32 is also a part of original jurisdiction of Supreme Court of India. Yes, Akif Mansoor ji, you are correct. Pre-constitutional, D is the correct answer. Question number 7. As per Constitution, Khap Panchayat have no authority to order honor killing is held in. As per Constitution, Khap Panchayat has no authority to order honor killing is held in the case of A. Shanti Vahini versus Union of India. B. Shanti Bhushan versus Supreme Court of India. C. Roopjan Begum versus Union of India. And D. Lalita versus State of Chhattisgarh. Shanti Vahini versus Union of India. Shanti Bhushan versus Supreme Court of India. Roopjan Begum versus Union of India. And D. Lalita versus State of Chhattisgarh. Question number 7. Khap Panchayat have no authority to order honor killing. It was held in the case of. Question number 7. Its correct answer is A for Ahmedabad. That is Shanti Vahini versus Union of India. Yes, Harshvardhan Gautamji, you are correct. Shanti Vahini versus Union of India. Next question. Which of the following writs can be issued against judicial or quasi-judicial bodies? Which of the following writs can be issued only against judicial or quasi-judicial bodies? Question number 8. A. Habeas Corpus. B. Mandamus C. Certiorari D. Quo Warranto. Which of the following writ can be issued against the judicial and quasi-judicial bodies? Sir, this is Shakti Vahini. Yes, Harshvardhan Gautamji, you are saying this is Shakti Vahini, right? But if you will follow up the question paper, I can show you they have mentioned it Shanti Vahini, right? And I have to follow up that particular question paper. I know there can be some of the errors. Until and unless there is not a major error, I cannot change it, right? Akif Mansoor, D, I guess. No, Akif Mansoor. Its correct answer for question number 8, the correct answer is the writ of your certiorari. Writ of certiorari, that is C. Okay, writ of certiorari can be issued against judicial and quasi-judicial authorities, right? Now, next question. Question number 9. Article 24 of Indian Constitution speaks about A. No child below the age of 14 years shall be employed to work in any factory or mine or other hazardous employment. B. No child below the age of 12 years shall be employed to work in any factory or mine or other hazardous employment. C. No child below the age of 16 years shall be employed to work in any factory or mine or other hazardous employment. D. No child below the age of 10 years shall be employed to work in any factory or mine or other hazardous employment. Question number 9. It is directly related with Article 24. Quite easy to answer. Harshvardhan Gautamji. Yes, A is the correct answer. No child below the age of 14 years shall be employed to work in any factory or mine or other hazardous employment. Now, last question from Constitution, that is, which article of Constitution of India provides for uniform civil code? Question number 10. Which article of Constitution of India provides for uniform civil code? Yes, Akif Mansoorji is the correct answer. Option A, Article 42, B, Article 43, C, Article 51A, D, Article 44. Which of the following article of Indian Constitution is talking about uniform civil code? Akif Mansoor, that is Article 44. Yes, Akif Mansoorji, Article 44 is the correct answer. Now, question number 11. Question number 11 is belonging to CPC, that is Code of Civil Procedure 1908. Under Order 32 Rule 9 of CPC, a next friend of a minor can be removed. Under Order 32 Rule 9 of CPC, a next friend of a minor can be removed. A. If he ceases to reside in India during the pendency of suit. B. Where his interests become adverse to that of the interest of the minor. C. Where he does not fulfill his duty or obligation. D. For any of these reasons. Under Order 32 Rule 9 of CPC, a next friend of a minor can be removed if he ceases to reside in India during the pendency of suit. B. Yes, Harshvardhan Gautamji, D is the correct answer for question number 11. That is, all these three conditions, like if any of these conditions has not been fulfilled, that can be a ground of removal of next friend of a minor. Right? Next, question number 12. Which section of Code of Civil Procedure 1908 embraces the principle of restitution? Restitution, that is modification of the decree or reversal or variation in the decree which has been passed by the lower court. This is the principle of restitution. This particular principle is embraced under which section? A, section 134, B, section 144, C, section 148A, D, section 151. So, which of the following section of CPC is talking about the principle of restitution? 134, 144, 148A and 151. What should be the correct answer? Yes, it's correct answer for question number 12. The correct answer will be B for Bangalore. That is section 144. Section 144 is talking about the principle of restitutions, right? Next question, that is question number 13. Under B12, 12B, section 144. Yes, Harshvardhan Gautam ji, you are correct. Under Civil Procedure Code, when application for review is dismissed, A, appeal can be filed against the order. B, no appeal lies. C, with the permission of court, appeal can be filed against the order. And D, none of these. Where an application for review is dismissed, what is the remedy the person is having? Appeal can be filed. B, no appeal lies. C, with the permission of court, appeal can be filed against the order. And D, none of the above or none of these. Question number 13. What should be the correct answer? Question number 13. Its correct answer will be yes, B for Bangalore. That is no appeal lies. In case where an application for review is dismissed, the party is having only the remedy, that is to filing a fresh suit, right? Question number 14. Question number 14. Just a second. Where in order allowing amendment, no time is prescribed, then the amendment can be made from the date of order in A, a reasonable time, B, 14 days, C, 60 days, D, 3 days. Where no particular time has been prescribed for the amendment and the parties have given time for the amendment in the pleading, like in how much time period they can make amendment in their pleading. A, reasonable time, B, 14 days, C, 60 days and D, 3 days. Its correct answer will be B for Bangalore, that is 14 days, right? If you can follow up this particular provision of Order 6, Rule 18 is talking about amendment in the amendment in the pleading. So its correct answer will be B for Bangalore, that is 14 days. Next question. Where an injunction has been granted without giving notice to the opposite party, the court shall make an endeavor to finally dispose of the application within A, 15 days, B, 30 days, C, 60 days and D, 90 days. 14 ka yes, B is the correct answer. Harshvardhan Gautam ji. 15. Where an injunction has been granted without giving notice to the opposite party, the court shall make an endeavor to finally dispose of the application within 15 days, 30 days, 60 days and 90 days. What should be the correct answer? Question number 15. This particular question is dealt under your CPC Order 39. Right? Question number 15. What should be the correct answer? Its correct answer is B for Bangalore, that is 30 days, right? Where an injunction has been granted without giving notice to the opposite party. Yes, Harshvardhan Gautam ji, B is the correct answer. The court shall make an endeavor to finally dispose of the application within next 30 days. Next question, question number 16. No arrest and detention in civil prison can be made if the decree is for the payment of A, not exceeding rupees 2,000, B, not exceeding rupees 3,000, C, not exceeding rupees 4,000 and D, not exceeding rupees 5,000. No arrest and detention in civil prison, civil imprisonment can be made if the decree is for the payment of A, not exceeding 2,000, B, not exceeding rupees 3,000, C, not exceeding rupees 4,000 and D, not exceeding rupees 5,000. What should be the correct answer? Question number 16. What should be the correct answer? Jaldi se bataiye. I hope all of you will be having the idea what should be the correct answer for this question. Question number 16. No arrest and detention in civil imprisonment can be made if the decree is for the payment of 2,000, 3,000, 4,000, 5,000. Question number 15, Harshvardhan Gautamji is saying D. No, Harshvardhan Gautamji, for question number 15, correct answer will be B, that is 30 days. Question number 16, its correct answer is A, Ahmedabad, that is not exceeding rupees 2,000. Here you have to remember that if a court passes a decree or like for the payment of the money between 2,000 to 5,000, the person can get the imprisonment of 6 weeks. And if the court passes any decree for the payment of money above rupees 5,000, then at max that particular person, judgment debtor, can be sent to the civil imprisonment for 3 months. And below rupees 2,000, there will be no detention at all. Yes. Next question. Question number 17. As per section 148 of CPC, the court may enlarge the prescribed period of A, 15 days, B, 30 days, C, 60 days, and D, 90 days. This is your question number 148. This particular question is from section 148 of CPC, that is talking about enlargement of time by the court. So, what should be the correct answer? 15 days, 30 days, 60 days, and 90 days. Question number 17, its correct answer will be B for Bangalore, that is 30 days. Now here you have to remember this thing very much clearly, that under section 148A, that is talking about right to lodge caveat, there the caveat shall remain in force for 90 days. So under section 148A, the caveat shall remain in force in 90 days, while under section 148, the court can enlarge the time for the maximum period of 30 days. That is, B is the correct answer. Yes, Harshvardhan Gautamji, 17 ka B is the correct answer. Question number 18. Even after ex parte proceeding, defendant can take part in further proceedings of the suit. This principle was propounded by Honorable Supreme Court in the case of A, State of Bombay versus United Motors, B, State of Rajasthan versus Vidyavati, C, Vijay versus R.N. Gupta Education Society, D, Arjun Singh versus Mohinder Kumar. Even after ex parte proceeding, the defendant can take part in further proceedings of the suit. This principle was pronounced by Honorable Supreme Court in the case of State of Bombay versus United Motors, B, State of Rajasthan versus Vidyavati, C, Vijay versus R.N. Gupta Education Society, D, Arjun Singh versus Mohinder Kumar. What should be the correct answer? Question number 18. Its correct answer is D for Delhi, that is Arjun Singh versus Mohinder Kumar. Next, judgment. Question number 19. Judgment and decree passed by the court which lacks inherent jurisdiction. Judgment and decree. Yes, question number 18 ka correct answer is D. Harshvardhan Gautamji, you are correct. Question number 19. Judgment and decree passed by the court which lacks inherent jurisdiction is A, is a nullity, B, would never operate as res judicata, C, can be challenged in the subsequent suit, D, all of these are correct. Judgment and decree passed by the court which lacks inherent jurisdiction. A, is a nullity, B, would never operate as res judicata, C, would be challenged in the can be challenged in a subsequent suit, D, all of these are correct. Question number 19. Its correct answer is D for Delhi, that is all of these are correct. Because if a court passes a decree or judgment which is not having jurisdiction, that particular court is not having jurisdiction, so it will definitely going to cause nullity of that particular judgment or decree. It will never operate as res judicata and can be challenged in the subsequent suit. Next question, that is question number 20. Under which provision decreed amount may be directed for the payment in installment after passing the decree? Question number 20. It is again a statutory based question. Rule 10 Order 20 of CPC, Rule 11 Order 20 of CPC, Rule 12 Order 20 of CPC, and Rule 10 Order 21 of CPC. The provision which is talking about decreed amount may be directed for payment in installment. So decreed amount can be payment in installment. This is what held in which thing? Yes, Harshvardhan Gautamji, 19D is the correct answer. 20, its correct answer is B for Bangalore. That is Rule 11 of Order 20 of CPC. This particular provision is talking about payment of decreed amount in installment, right? I hope it is clear to you all. Now, if you people haven't 20 ka, yes, B is the correct answer, Harshvardhan Gautamji. Very good, Harshvardhanji. You are remembering statutory provisions as well as the conceptual clarity you are having in your mind that will help you in your MP prelims exam. Now, if you people have attended the class till now and if you found it useful, don't forget to like the video, don't forget to subscribe the channel, and don't forget to press the bell icon. And if you haven't checked out MP Civil Judge Prelims ka crash course, link is in the description mock. Our live mocks are ready, so you can attempt the live mocks. You can make the live mocks interactive discussion, one-on-one mentoring and doubt clearing session. So that is it for the day. मिलते हैं next class में with some fresh or new discussions. Meanwhile, take care. Bye bye. Stay healthy, all of you.